Yes.
Adjournment request from item number 1 to 14.
May I please, my lord? I'd like to mention item number 1, my lord, with the consent of
Circulate.
oblige, my lord.
Take the date.
9 February.
So, ma'am.
9 February.
Yes.
May I please, your lordship. Item number 6. Lordship, may not take up this matter, lordship, as there is an order of your lordship that to place the matter in appropriate bench.
I can't.
Item number 6, lordship.
What do you want?
Lordship, this matter, there is an order, lordship, order that,
What do you want? Tell us.
any appropriate bench, lordship.
Let it be called out.
Lordship.
We'll see the notings. and then
Lodge.
we shall pass.
Lodge.
All right, sir. Yes.
No.
From item number 15 to 22.
May it please your lordship. Lordship, this is with regard to item number 22. I'm appearing on behalf of Mr. D.K. Das. He has underwent an eye surgery. So with the consent of the opposite side, we are seeking 2 weeks' time.
As paid for, you're for the petitioner.
Yes, your lordship.
23.
As paid for on behalf of the petitioner on account of disposition of the lawyer who is to address this. The matter is that
27 2.
My lord, I pray for adjournment of item number 21, my lord.
adjournment slip already.
I'm grateful, my.
25 2.
Please, Milot. Let's, with regard to item number 18, Milot, I pray for an
18.
adjournment, Milot. Yes, Milot. I pray for an adjournment with the consent of the other side, Milot. There's a talk of settlement which is going on between APDCL and the appellant. Milot.
Your Mr.
Mr. A. Gautam, Milot.
Mr. Gautam. Mr. A. Gautam learned advocate for the appellant. Admits that the talks of settlement are underway. He therefore seeks an adjournment after having obtained the consent of the advocate to the other side. List this matter sometime tomorrow.
March. 16 March.
Grateful, Milot.
Any other request?
Yes.
Daily list for orders item 2.
My lord, my friend appears for respondent number 8, my lord. My friend appears for respondent number 8, my lord. The office note indicates that neither AD card nor conserve notices have arrived. But my friend has received on behalf of the client.
Lordship, we have received the brief only yesterday, Your Lordship. We'll be
That's
filing
great.
a
So
Carlos
the
Pavan.
pleadings, I mean, the service is complete.
Yes, service is complete.
So we'll fix it for admission
Right.
under on a particular date.
My lord.
Be ready in the meantime. If you're required to file any affidavits, you can do so.
Lordship.
Take down the service of notice on all respondents is complete. So let this matter come up for consideration in the consideration under the appropriate heading on
18 March.
I'm grateful, my lord.
Yes. Item number 3.
This is a review application preferred by the state of Assam.
Yes.
In the month of February or March last year, Lordship, there was a direction that we should give paper notice publication because there are more than 500 respondents.
Yes.
Some of them have appeared. So, and we have filed the affidavit also with the fact that paper publication has been done. So Lordship may be pleased to pass an order for completing the service. And if Lordship is pleased, then a date may be fixed for hearing.
Now we'll fix a date for hearing.
Lordship.
But then has somebody approached the Supreme Court also?
Some have.
Some have. So we'll have to await the decision.
And then a longer date may be given for hearing.
We have filed an IA, my lord, seeking implement in this case, my lord. My IA is, my lord, 3846 of 2025.
We will have you impeded. First,
Fine.
let the service be completed on
Fine.
all respondents,
My lord.
and then you press your IA. We will pass necessary orders.
Fine.
Because we'll be fixing it in April.
Lordship.
Take down. It appears that some of the respondents have yet not been served. Though paper publication has been made. some respondents have not yet appeared despite paper publication of the notice having been made. Some of the respondents have also preferred SLP against the impugned judgment, which the state seeks to get revised. The service of let all the respondents be served. In the meantime, list this matter under the appropriate heading on
6/4. 6 April.
Deeply obliged.
Item number 4.
service report.
May I please your lordship? Lordship, as per the office note dated 9/1/26, neither AD card nor unserved notice nor any service report in respect of respondent number 10 and 11 has been received, lordship.
Lordship, I am appearing for respondent number 10 and 11, your lordship. We'll
And
be filing
11
our
who appears for 11. You appear for both.
for
10
10 and 11 both.
All right, so you need to respond.
Yes, your lordship.
All right.
Need some
Mr.
time.
What is your name?
I'm KJ Saikya, your lordship.
Mr. So-and-so has appeared on behalf of respondents number 10 and 11, who seeks some time to put in his response to the petition. Let this matter come up under the appropriate heading on
Lordship,
18 March. 18/3.
Much obliged.
deeply obliged.
Item 5.
My lord, in item number 5, as per the office note, respondent number 6 has not been served.
Yes.
Lord, this is a matter continuing from 2019. So, my lord, we may be permitted to take Dasti, my lord.
Mr. Kane
Some
Chaudhary-
urgency because I'm retiring in July.
Mr. Kane Chaudhary, learned senior advocate, submits that till date, respondent number 6 has not been served, even though this matter is running on the list for a long time. He therefore prays for permission to serve respondent number 6, Dasti. So permission is accorded on deposit of requisites for issuance of notice. Notice Dasti, the office shall hand over a copy of the notice to the counsel for the petitioner, counsel for the appellant, to be served on respondent number 6. The appellant shall also furnish an affidavit, furnish a report regarding service of notice or service of Dasti notice on respondent number 6 in the registry immediately after the service.
Well, we may be given liberty to mention the matter, my lord.
Let this matter come up under the appropriate heading on. We have a date in early April.
My lord,
March.
he is retiring in July, my lord.
So April,
Next month.
March. So we keep it in March.
Or my lord, let us first serve the notice. Liberty be given to us, we'll
But we have to
mention.
fix a date. Anyway, we fix a date in February. Late
February, last of February. my lord.
Last of February, with the liberty to, we have fixed a date.
Yes,
27 February.
deeply.
Item number 6.
Additional affidavit. Let me see. What? Yes,
Right.
what is the matter?
Lordship, this writ appeal was disposed of lordship by a different bench lordship, and accordingly, this IA is filed to comply with the order passing the writ appeal. So lordship has passed an order on 1610.
No, what is SIA? I mean,
IA is only to, yes.
compliance of a judgment which is under challenge. This is an appeal, no?
Appeal,
is-
yes, lordship.
what kind
Appeal,
of IA?
appeal has been disposed of lordship,
Appeal has been disposed of.
disposed of, directing the.
You don't file IA for, we are not executing bodies if it is.
Lord-
No. No, this application shall be rejected. You file the appropriate application. If a time limit has been given by the judgment, you can file contempt or whatever, but not IA.
Lordship, actually is that lordship, the respondent was directed to lordship, comply with the order within 30 days. Before 30 days, lordship, they have hand over the lordship guidance to another.
I mean,
So only-
we can't re-adjudicate the matter. No, this is not a executing court. If there is, you file necessary application. This I file. No.
Lordship may
find
take
out-
up the matter day after tomorrow, Lordship.
You just check up whether this is the correct forum.
Lordship.
You need to approach the court. No, he is asking for compliance of the order passed. No,
Lordship,
As
day
per-
after tomorrow.
no, next week. You
Lordship.
apply your mind and then
Lord.
file any application. As prayed for on behalf of the appellant applicant, re-notify on so. Give after 2 weeks.
Lord.
11
Alright.
March, 11 February, sorry.
Push link.
Item 7,
First time.
Lordship.
Yes, what do you have to say?
Today I'll file Wakalatnama on behalf of respondent number
That's right. With respect to the
3,
uh,
4 and 6, my lord.
others have not been served.
5, my lord, is not represented.
Other is the state.
Private respondent number 5.
With the private respondent.
Hmm?
Private respondent number 5.
He has not been served.
No.
Look here. All others except respondent number 5 have been served. Stop. Awaiting the service of notice on respondent number 5, the matter is adjourned to next week. Inform if you have any idea,
My lord.
because, right, because 47 days we would condone.
My lord.
But the other person should be here.
Yes,
Take up the brief or do whatever. Next week we are going to do it.
my lord. Highly obliged.
So and so.
30th January.
Where the bit delay.
Item 8,
Please, your lordship. Lordship, this is interlocutor application filed under section 5 of the Act for condition of delay of 419 days, your lordship. For preparing writ appeal.
All still. Vote. MS Bora, are you ready to take up the notice
I am for 2 and 4.
and
What
rest
are-
others?
Water Resource Department.
So what do you say? You wish to challenge this?
Delay.
You wish to contest this? Don't talk amongst yourselves. Talk to the bench. Look here, what is your name? MS so and so and so and so. London councils appearing for response number so and so. Seek some time, accept notice and seek some time to contest the present petition, seeking condonation or delay of 419 days. 419 days.
Yes, sir.
419 days in preparing the appeal. Stop. Let such affidavits be filed. Let
And
such
for- and
response be filed positively by the next state. Re-notify on 2 weeks. 2 weeks is good enough time.
25/2. Item number 9,
Well, it's
Take care. Do you require that? You don't require it.
I'm praying because without leave, I can't, of
No.
course, I can't file. I can go in SLP, but I can also file.
It's absolutely superfluous, Mr. Srivastava.
My lord, this is alternate remedy. My lords can of course decide whatever way my lords consider necessary. But this is also one of the rights given.
Applicant seeks leave to file an appeal before the Supreme Court under Article 134A of the Constitution of India. No leave is required to be obtained for filing such an appeal. The petition is misconceived, dismissed. The application is misconceived.
Grateful minutes.
Withdraw it. Why do you have to say all this?
My lord, there is an issue. Academic issue minutes. There is an issue minutes.
Mr. Srivastava, better instead of our saying that it is misconceived, take a withdrawal.
They can say, my lord, but just there is one issue minutes, just academic.
No
issue.
issue, Mr. Srivastava.
No, there's academic issue minutes, purely for law.
We are not inclined.
My lord, this is necessary because
Anyway.
Karnataka High Court
dismiss
minutes,
this.
my lord, Karnataka High Court has said that this leave should be asked immediately at the time of pronouncement of the judgment. It's a full bench.
We don't follow.
And so anyway, minutes, whatever order my lords have passed, I bow down minutes. Grateful minutes.
My learned friend already approached the SLP.
No,
and
no,
that
we
has
have
been
not filed.
dismissed.
We have not.
He has already approached the SLP.
Yes,
No, no, no.
my lord, if
No,
your
no,
lordship
not
look at-
against the last order, madam. That
at
was
page- no,
earlier
no.
minutes.
The main order, if you.
That was earlier minutes. That is against the merits. Lords, I want to
Please,
go
please, 180
again, once again, against the last order, 24th October 2025. Grateful minutes.
No, against the writ appeal, my lord, they preferred this SLP.
And which certificate do you want us to give you? Mr.
Minutes,
Srivastava?
my lords have latest order is 24th October 2025.
What is that?
That my review was dismissed. Saying, holding that there is no patent error and, my lord, with due respect, no injustice has been committed to
Mr.
the
Srivastava,
applicant.
this could entail a cost.
Well, I bow down.
No academic issue.
Uh, Anyway, minutes, I bow down. Yes, grateful minutes.
Item
like-
10 and 11.
Well, in these cases, my lordship wanted to, but not list the some connected matters. But two were listed. There is one more, there are some defects. We have cured the defect today. I have served the copy to London friend also. But let it be all these cases be listed together.
Well, let's. see
Defects
what's the matter.
defects we have cured today, my lord.
Just a minute. Mr. Roy, what order did we pass on the last day?
Last page, my lord, lordship wanted the connected matters to be listed
What
together.
are these connected matters?
My lord, there were three appeals.
Appeals against the same.
Again,
government.
my lord, connected, my lord, similar identical matters. Three employees working in the same shed. So identical issues are there. Therefore, my lord, your lordship wanted all this matter to be heard.
You have filed the appeals separately against each of the employees.
Yes, yes. But the one more was my lord, left. It was cured today. I have served the copy to my lord, friend is also there. My lord. He will appear in the case. My lord.
Give us the number.
But my lord, there is a only filing serial numbers because there is defect. I'll give it to the.
On the last occasion also, we passed a vague kind of an order that two more are to be filed. What is that? That's
Yeah,
it.
I lost
We are
it.
only adjourning it. On that day, you tell us that this is the number, this is ready, we will fix it.
Lordship.
As- As prayed for by Mr. P.K. Royal and senior advocate for the appellant, let this matter come up for consideration after 3 weeks.
No.
Hmm.
16 February.
16 February.
16 February.
16
February.
Deep blue list.
Item 12.
Wait, please, your lordship.
Yes.
My lord, the reasoning of the learned single judge.
Now you have to start afresh.
Yes,
What is
now what had
reasoning? What is
happened,
the
my lord?
case?
A particular plot of land was given to the allotted to the appellant, not appellant, predecessor society of the appellant
Hmm.
for opening a school.
Hmm.
Now, my lord, thereafter, the school in whose favor the allotment was made an arrangement with the present appellant for running a school.
Can that be done?
So, my lord, the learned single judge assigns the reason.
Forget about land single judge. Let's start it
No, my
afresh.
lord, no, my lord, it's something like this, the entity itself has merged into this in the form of the appellant. That is how the things were
For
done.
that also permission would be required, no? Land
No, my lord,
authority.
in
or
that
some-
case, at least I am entitled to a notice that this is the wrong you have committed. Why not we cancel the allotment? Nothing has been done. Well, these are all technical things. My lord. End of the day, it's a school.
Not, it's a school, all right.
A school.
So now it has been
No, my lord,
re-allotted.
under the land policy of the state, if a land is allotted, government land is allotted subject to payment of premium, then if the land is not utilized for the purpose for which it is given, then after 3 years, land vests in the government. That is this, position obtaining. It's not that the school is not running. And the learned single judge assigns the primary reason of the lot, it being a VCR land.
VCR में public purpose के लिए
हाँ।
project.
Is a school not a public purpose? Is not a public institution?
That the president of Kathau Ashram Community High NWGWR Bijni का ward for Bodoland.
If lordship comes to page 38, para 10 of the judgment, my lord. Or before that, let me place the facts, my lord. Yes. Page 72, my lord, is the subdivisional level committee's recommendation. On top, page 72.
Yeah.
The proposal for allotment of land measuring 1 biga 3 kata 10 lesa covered by Doug number so and so, vizier of Bisney Town is approved by Land Advisory Committee in the name of Bisney Town, Swarng ME School, subject to approval of the reservation proposal by the government.
So has this been de-reserved?
No, Milord. It has not been. It has not been. To be honest, that has not been done.
Who appears for BTC?
Lordship, name has not been shown in the cause list, Lordship, as BTC. So, Lordship, we are not aware of
What is your name?
this MSN
Petition.
surgery. MSN
Copy was
surgery.
served, Milord. Of course, there is a transition. Earlier, there were maybe when you filed it, a separate set of councils were there.
Chaudhary, learned advocate, accepts notice on behalf of BTC. BTC. BTC and MS. Who is it? What is it? Then borderline.
And surgery, Lordship. MS. The names are not shown.
That's all right. MSN borderline. Learned
Copy to
advocate
DIA
accepts
session.
notice on behalf of
Copy
respondent number.
सबके दिया था।
On behalf of respondent number.
Within part में copy तो दिया था।
Respondent number 3 accepts notice on behalf of respondent number 3. You have accepted notice on whose behalf? Mr. Chaudhary?
Lordship, copy is not there.
I think she can accept for Milord 1, 2, 3, 4, 5, 6, 6 Land Advisory Committee. 6, 6, 6, 6.
No, not 6. Land Advisory Committee.
Yes, yes,
control
it is of the yes. Up to 6 BTC council
So I
can
think
take.
MS Chaudhary only can receive notice, no?
Yes. And my learned friend can take, I think 7 also, inspector of school, because education is also a subject which stands transferred. Up to 7, my learned friend can appear. 8 also. 8 also. Only Milord, 9 is a private party.
No.
Okay,
We are not concerned with 9 for the moment.
Yes.
We might issue notice. Just a minute. We'll be asking you a different question, not what has been decided by the learned single judge.
Lordship.
How can you re-allot under such circumstances without de-reserving the BCI?
Yes.
Lordship,
Your entire mechanism has been thrown to the winds. You
Lordship,
can't possibly do that. Mr. Chaudhary may not gain, but you cannot be allowed to do this.
Lordship,
I don't think she's getting it.
allow
You,
some,
you don't have
allow
the
some,
copy.
yes, Lordship, at this present
Maybe,
moment.
maybe
Lordship,
she is not aware of the facts also.
All right. We will not ask you further. Now accept notice at least
Yes, Lordship.
as a LIFO. I think I could. A VGR land was originally allotted to Bijni Town Swarang ME School in 1997 by the Subdivisional Advisory Committee of Bijni. The school was run for some time, but it was closed down. But it was closed down. Full stop. Contemporaneously, the managing committee of the school referred to above passed a resolution to transfer the land and the building of the school to the appellant / Global Modern Academy and another. And also issued a no objection certificate for formalizing this arrangement. the appellant started running the school under the name and style of Global Modern Academy after receiving permissions and upgrades from the Department of Education under the BTC. In fact, the ongoing operation of the school was recognized by the BTC. Sometimes in the year 2022, the secretary of the BTC issued an order allotting the same plot of land to respond number 9, a body which is engaged in religious activities. This allotment, in fact, tantamounts to cancellation of the earlier allotment of land without any formal approval from the Land Advisory Committee, which, according to the appellant, is not permissible. Is not permissible. The writ petition preferred by the appellant was dismissed. Upholding the dismissed, upholding the allotment to respond number 9, notwithstanding a declaration in the order, declaration in the impugned judgment that the land in question is a VGR land and it is not permissible to allot the said VGR land. To any individual, but the rule could be relaxed for public constitution. The issue with the public institution, the learned single judge therefore opined that respond number 9 is a public institution, and therefore the allotment of land in question to it was not in breach of any statutory requirement. Challenging this judgment, Mr. Chaudhary, learned senior advocate, has argued that before doing that, a formal cancellation order was necessary, more so when the appellant was permitted to run the school with all permissions in the past and necessary upgrades required for running an educational institution. However, we are at a different issue altogether, namely whether, without de-reserving the VGR, any allotment could be made, question mark. So the records reveal that the first allotment to Bijli Town Swarang ME School in 1997 was also conditional, and it was subject to the approval of the de-reservation proposal by the government. There is no clarity from the records whether such a proposal of the government has been approved and the VGR has been de-reserved, which would only authorize the BTC to allot lands to institutions. The response of the respondents would be required for deciding the issue, for deciding the issue. Let notice also be issued to respond number 9 on steps being taken by the appellant within a period of 1 week, both modes returnable on so and so date.
My lord, there is a caveat. For 9 days.
That's something else. Reallotment amounts to closure of the school. What happens to the students? Yes.
Lord, the respondent number 9 appears by an caveat.
I am appearing to the respondent number 9.
Issue notice, है ना? Issue notice to respond number 9. Notice is accepted by Mr.
FP board भैया.
So and so. वो सब कर देना. So let the matter come up for consideration on. We are fixing in late February, only for the reason of students studying in that school on so and so date, by which time the affidavits, if filed, ought to be exchanged.
25-2.
I copied it.
25-2.
We also deem it appropriate to impede the State Revenue Department of Assam.
But it's a transport subject.
No, even that.
Transport subject.
That's all right.
Revenue.
Subject, but still.
Regarding compliance of 95A. Regarding
State Revenue Department. Let the State Revenue Department be added as respond number so and so.
I will serve a copy.
Mr. Chaudhary shall furnish a fresh memo of appeal in the registry within a period of 2 days.
No, we can serve straightway upon the.
No, you will do that. Notice to so and so, notice to the newly added respondent / State Revenue Department is accepted by MS and M or N.
And for Nagaland.
N for Nagaland. N Bordoloi. You could have spoken out your name instead of state.
I think we'll have to furnish the amended cost title also.
We have said that.
Yeah.
We have said that.
Well,
Accepts notice on behalf of respondent number 9. Affidavit on the affidavit of newly added respondent number so and so also need be filed by the aforesaid date.
25-2. Item 13.
Yes, Mr. Boyan.
My lord, may I please as your lordship? My lord, the fact of the case, my lord, is that the petitioner, my lord, was the principal of a purely private college, my lord, Karimganj Law College, my lord. And my lord, being agreed with the interference of the deputy commissioner, my lord, while constituting the governing body of the college under his seal and signature, my lord, he put him to challenge the same constitution. And, my lord, subsequently, when, my lord, the matter is in session before this honorable court, my lord, that managing committee has instituted a departmental proceeding against the present appellant, my lord, and terminated him from the service also. Now, subsequently, in the second writ petition, my lord, his termination order was also under challenge, but both the writ petition, my lord, came to be dismissed, my lord. That's why, my lord, we have preferred this appeal, my lord.
Yes, tell us your grounds.
My lord, the grounds is that, my lord, there is a law, my lord, which is governing the, my lord, how a managing committee is required to be constituted for these categories of colleges, my lord. Now, my lord, may straight away can come to page 60, my lord.
Page 60.
Yes, my lord, page 60 and internal annexure 2, my lord, it is a part of the writ petition, my lord. my lord, this is a extract of the resolution of the 60th meeting of the affiliation committee held on 13/3/2020, subject to ratification by the Academic Council of Executive Council of the University. Item number 4, report of the inspection commission received from Professor so-and-so. My lord, can skip this two-part, my lord, and we can straight away can come. My lord, the clause 1, the college should take adequate care in future to ensure that the matter related to the annual renewal of the affiliation is carried out on time, and in no case it should be kept pending. Any adverse consequences arising out of delay in matters relating to the renewal of affiliation may jeopardize the status of the affiliation of the college with the university, for which college may be held responsible. The college must immediately initiate necessary steps for installation. So, my lord, these are all procedural issues. Further, the library, my lord, can find a common room. Lastly, my lord, the society running the administration of the academics of the college should mandatorily be registered. My lord, there is a direction from the university which has affiliated the colleges, my lord, of this nature, and this college had been affiliated, my lord, by the Assam University Silchar. Now, my lord, as per this affiliation, my lord, these categories of colleges is required, my lord, to be run by a, my lord, society which is required to be registered, my lord. My lord, before this,
No, just a minute.
My
What is that affiliation letter?
my lord, the affiliation letter. Huh? Yes, my lord. Oh, that's the affiliation. My lord, perhaps that affiliation is not been annexed here, but it has been affiliated, my lord. If my lord want to peruse, my lord, I can.
No.
My
We
lord,
are only
my lord,
referring
my
to
lord.
that for the reason that it must have some
Affiliation.
conditions. Affiliation subject to the institute
yes,
being
my
run by managing committee, and
My-
managing committee, what would be the composition of the managing committee? Is that the
Yes, yes,
condition
con-
in the affiliation?
Yes, yes.
Where is that?
My lord, that.
So you should have brought it, no?
Yes, my lord. Yes, my lord. That is
Mr.
a
Pawan,
vital,
if
that
you
is a.
want, if you have been dismissed from service,
My lord.
the entire committee has been reconstituted.
My lord,
This thing just says that, no, this is no reconstitution, this is not something new, it has only been revamped. And that's the reason why Article,
My lord.
226 has been invoked.
My lord.
So you should give us that, no?
Yes, my lord, one chance, my lord, kindly be
One
given.
chance.
My lord, I will bring it
Then only
on
we would have
record.
decided your case, no?
My lord, I will bring it on record, my lord. Some hurriedly it had been filed, my lord.
Why do you file applications so hurriedly?
My lord, my lord, jobless, my lord. That's why, my lord. No,
Definitely, yeah. An affiliation, no, we would like to see the
My
terms
lord.
of the affiliation.
my lord.
See, the 60th meeting of the affiliation
yes.
committee does not talk about any revamping.
Correct me.
It is the managing committee. We are not supposed to give you the grounds, no?
Yes.
So this is
my-
only the managing
My
committee.
lord, my lord, in fact, the law has been settled by the our honorable
This is
court. my lord.
this is what you both sides argued before the learned single
Yes,
judge, and
yes.
therefore this judgment, no?
This judgment, yes, my lord.
What has been settled?
My lord, the
Where is the talk about the requirement of changing the statutory committee, the managing committee?
my lord. No, my lord.
Where is that? What should be the composition? Does the affiliation talk about it, or we should go to the Assam University route?
My lord. My lord, there is a.
And it was only yearly affiliation.
My lord.
So where is the continuity of the affiliation?
Continue. My lord, I will try to bring it on record.
You have to complete it. No, you have been dismissed from service. You are not careful about your own case.
My lord.
I mean, I'm talking about your client.
No, my lord.
Mr. Bhuya, after some argument, seeks some more time to bring in, to
For which lawyer?
bring on record the letter of affiliation of the Karimganj Law College with the Assam University, which entails certain conditions for the management of the law college. Next, the Karimganj Law College a privately managed institution, privately managed and unaided institution, was established in 1984 The college was being run by a steering committee which handled all administrative, academic, and financial matters with its own finances. The steering committee was initially formed by a sponsoring committee and included members like the guardians, the teachers, the non-teaching staff, and others. The college was affiliated academically to Assam University, Silchar, and professionally to the Bar Council of India, requiring compliances with their regulations, such as UGC affiliation rules of 2009 and BCI legal education rules of 2008. It appears that in the year 2020, the Assam University mandated the formation of a registered society / trust to manage the college. Which prompted the steering committee, which actually, what did I say? What did I say, Kunanji? Formation. Which prompted the steering committee to initiate steps for drafting of bylaws, finalizing objectives, and collecting memberships. However, in 2023, the then Deputy Commissioner of Karimganj convened a public meeting and directed for the formation of an ad hoc management committee. This management committee superseded the steering committee for 3 months to form a permanent society. A permanent society thereafter came into existence with 29 members, which was notified by the Deputy Commissioner in 2023. The appellant was suspended by the new managing committee and was also proceeded against departmentally and ultimately was dismissed from service. Mr. Bhuyan, learned advocate for the appellant, submits that the Deputy Commissioner did not have the power to convene such public meeting and direct for formation of ad hoc / new management committee. So this was a culpable exercise of power without any reason, as the affiliation rules and the requirements under the letter of affiliation did not come in. In this context, we require to see the letter of affiliation. Let this matter come up for consideration on that.
Milord, 2 weeks may kindly with
March.
18 March.
Oblige.
Item 14.
This is a read appeal against the judgment passed by a single man, where the substantial questions of law that has been involved in this case is as page 22. Page 12 is the substantial questions of law, page 12. Your lordship, the fact of the case is that the advertisement has been issued in this case of filling up the grade 4 post.
But
And
they don't go back to such
Yes.
details, no?
now what will
You
happen?
tell us whether the single judge has gone wrong
Yes,
in
Lord.
deciding the way in which the horizontal reservation has to be done.
Yes, lordship.
Now, he appears to have applied Rajesh Daria straight away
Yes,
and Tamanna Ben.
yes.
I think that's the correct exposition of law.
Now the lordship, if come to section 4 of the Assam Reservation Act, it clearly says that what only in the category way, where it cannot be migrated from the other section.
No. That's not the law, no? Where is section 4? Has it been quoted?
Yes, lordship.
Where?
In the page number 14, Three.
Internal page?
page number 14.
Internal page 14.
Yes, lord. Of my appeal.
Internal page is the picture.
the
Where is
reserve-
it?
The, at 3, section 4, reservation of the vacancies in the services and the post. There shall be reservation for 30% of the vacancy in services and posts under the state government in the favor of women in the stage of the direct recruitment. Provided further 30% of the reservation of the vacancies, the remaining unreserved category of the candidates are provided in the subsection shall be available to the women of
Just a
unreserved.
minute. Just a minute. I take it. Yeah, hold on for a minute. Shall be inclusive of the reservation. or otherwise. The proviso. As per. 30% में इसको भी लिंक करें और remaining okay. इसके हिसाब से तो where is that? There was a lot of clear. This is 2005 rule. यहाँ schedule at paragraph 26. Breakup. इसका नहीं पता चलेगा जनरल नहीं अलग अलग देखिए ये इसकी कैटेगराइजेशन एग्जिस्टिंग परसेंट इससे 3% टोटल Therefore, the first proviso does not collocate with second proviso. Where has it been dealt with by the learned single judge? Which paragraph?
Lordship, 21 of the para of the interim order.
Para 21. No, where has it been dealt with? That we have found it.
Yes, Lordship.
It is quoted there in paragraph 21.
Yes.
The argument that you're raising, where has it been dealt with? That this is separate from this 2005 rules.
Yes.
They make a separate provision which does not fall in line with what Rajesh Daria says.
Now, Lordship, in the Ram Narayan Kodi versus the state of UP in the.
Where has it been dealt with? Mr. Mahanta, you are appearing for High Court. Huh?
Para 35.
Para 35.
Page 130.
Nothing. Wait कर देंगे explain how. Which protection पे आ रही है? In Sadhana Singh Dangi, the wordings were different. Now we understand that the Supreme Court has in many cases said that unreserved category must mean and include every person of every category.
For all,
But here, these are specific provisos.
my lord.
How do we reconcile this?
No, my lord, that is, your lordship, kindly in my affidavit, I have.
This doesn't answer. Paragraph 35 doesn't answer. This is the logic employed by the learned single judge in
My-
paragraph 35. But then this logic defies the wordings. So without setting aside this part, this proviso, as constitutionally invalid. This interpretation, this has not only been read down, it has been totally substituted. You'll have to argue, Mr. Manta.
My lord, no, in my affidavit, my lord, I have, my lord, everything I have stated, but that affidavit is not been annexed here.
We are not concerned with the affidavit which you filed. You answer this question to us.
My lord, that is, there is a ambiguity.
Affidavit we might not even look
That
at.
is the ambiguity, because that,
You try and explain to us
my lord,
with case laws, because the law is, we understand it, Rajesh Daria, that is very specific.
correct,
Tamanna Ben says the manner in which it has to be calculated. Correct.
my lord,
So the single judge says that notwithstanding proviso 2, this is open for all.
yes,
Anybody could migrate because it's a horizontal reservation. So in that case, we'll have to say that the second proviso is not in tune with the law.
law.
Then only we can justify this.
My lord, give me some time, my lord, I'll file. Because that is the, probably that proviso itself is, my lord, against the solid principle of law, my lord.
Yes. Now do one thing.
My lord.
Now Sadhana Singh Dangi, you please tell us, that must be some other rules.
My lord.
Sadhana Singh
Singh
Dangi,
Dangi.
you just have that judgment. Please analyze and tell us. It's an interesting question of law.
My lord.
Correct. So this does not remain for us a case where he is involved.
For future also, my lord, yes.
Next week,
March, February, my lord, first week, February. First week or second week. But here in this case,
I
my
am
lord,
not giving any introduction because that will lean heavily in his favor.
my lord. Only another thing, my lord, already that my lord, that judgment has
You
already,
have to just
judgment has already acted upon, and one, my lord, Rubinath has come in, my lord. So if it is, my lord, interfered, then she will go out. But
that is not the question which
no,
we
she's not
should
made party
consider.
here,
That is not, we are not concerned with that.
my lord.
There should not be any wrong see, interpretation. My idea is, and my brother's idea is same.
That mean
The special horizontal reservation, there is no unreserved or reserved.
reserve, my lord.
There is no unreserved. But here the
Specific
wording of
provision
2005 is very clear.
that it will be filled up by
Section
unreserved only. It will be filled up by unreserved only. That is the language, my lord.
But we can always say that this is bad, provided that 30% reservation of the vacancies in respect of women for the remaining unreserved category
Remaining
of
unreserved,
candidates shall be available to women of unreserved. In that case, there could be no migration.
Only that,
Only for.
yeah, only for,
This is
that means even the meritorious. But unreserved, my lord, it is open for all, my lord. That is the,
that we understand.
my lord. But in that way, if I interpret it, then my lord, that proviso in that
But this proviso has to be struck down, no?
meaning, my lord, that is not been challenged, my lord.
Like here. And the judgment has been effected. They'll have to issue notice to the other person also, but let us see first you explain it. In case, try and explain it. We will also see, come, just make a note. Sadhana Singh Dangi, Saurav Yadav. Sadhana Singh Dangi, Saurav Yadav and वो तमन्ना बेन ये तीनों जजमेंट निकाल के हमें देना अभी नहीं फोटो स्टैंड तमन्ना बेन ये तो लिखा कोई मैं लिखा था गाड़ियां पर चला तमन्ना बेन अशोक भाई देसाई 2020 SCC online Gujarat 25910. All right, we'll see. Again, as prayed for by Mr. Manta, right, Mr. Which TJ Manta and Council for respond number
3 and 4, my lord. My lord. 3, 4 and 5.
3, 4 and 5. Let this matter come up for consideration on 26th of February. That's a Thursday, no? We'll hear it on the 26th of February.
My lord.
In the meantime, the registry should place on record the affidavit preferred by Mr. Mahanta. No, it's not. You have filed an affidavit here or there? Before that,
File in the writ petition that has not been annexed, my lord.
place this case along with the records of
My lord.
the writ petition.
My lord.
All right.
Item 15.
May I please, your lordship. Lordship, this matter has become infectious. I may be allowed to withdraw the same.
Mr. Your Parvez,
D. Gogoi, lordship.
Mr. D. Gogoi, learned advocate for the petitioner, seeks permission to withdraw this. But learned advocate seeks permission to withdraw this petition in order to, as it has become in practice. This list as having become in practice.
Item 16.
Highly blessed.
May I please, your lordship? Your lordship, the petitioner being here, the secured
Same
creditor.
issue, section 14 compliance. Now you people straight away come to the court without caring. I mean, they have to see that those 14 documents which they require for swinging into action. You people don't wait. Yes, what is the matter?
I shall take instruction.
Take instructions and tell us. The DM is supposed to facilitate, no? देखिए, इनका नाम बोला है।
2 and 3.
Is G, junior G. MSRB Bora, learned junior government advocate, seeks some time to take instructions in the matter. Let this case come up for consideration on after 2 weeks.
26-2. Item 17.
May I please, Lordship?
Yes.
Lordship, there is a case, my lord, where, my lord, because of misappropriation of money, employee was, my lord, convicted. And based on that conviction, my lord, in 2008, we have terminated him from serviceman. That conviction order was challenged before this honorable court in 2013, my lord, that was, my lord, interfered with. Now, in 2016, my lord, a writ petition was filed. Now, while this writ petition was filed, my lord, basic ground was that so far this conviction, since it has been interfered with, therefore the termination required to be, my lord, recalled, my lord. Now, my lord, what happened? The learned single judge, my lord, in paragraph 25 clearly decided that there is no error on the part of the respondent while passing the order of termination from service on the basis of conviction. Now, my lord, based on that, my lord, it is settled principle of law, my lord, no work, no wage, my lord, that is not a absolute rule. But the default of the employer must be, my lord, identified. And apart from, my lord, a relief was granted which was never paid for, my lord. Kindly see paragraph 25 contained in page 64.
Just a minute, give us 2 minutes.
64, my lord.
X.
We have, my lord, the legal point, my lord. Sorry.
You did not start any inquiry, no?
Yes, my, that is true, my lord.
Then-
So far the inquiry part is
Then
concerned, my lord.
how do we differ with the single?
Quite right, my lord. Kindly see, my lord, the challenge which has been made, my lord. Kindly see in page 68, the relief which was granted in column 1 to that period which was never paid for by them in the read petition.
Doesn't matter.
Second aspect, this issue was already
That
decided by,
argument is neither here nor there.
my lord, this is what already
The
decided,
court- And here the court
my lord.
on an issue which you raised.
But
Read
suppose, my lord, let us, that termination order will go, my lord.
Your
Then
first ground is that what the learned single judge was more indulgent.
Yes, my lord.
Now that is no ground.
My lord.
The writ court can always mold the relief.
My lord, absolutely, my lord, he is entitled, if suppose there is interference, my lord, to the termination order, understood, my lord. But lordship, on that point, my lord, the first principle is that the error of the employer must be, my lord, determined. My lord, the basic principle of law is that, my
Not
lord,
in
no
this
work,
case.
no pay is not absolute.
Look at
rule.
this. The man was suspended after an inquiry.
My lord,
He came to High Court.
my lord,
High Court asked him to go before the authority with a representation.
my lord,
The representation was decided in his favor because you have not followed section 9 of the rule.
my lord, my
So it was set aside.
lord,
Criminal case, there was conviction.
my lord,
Immediately thereafter, based on that conviction,
my lord,
he was dismissed.
my lord.
Now that conviction was set aside, not only on the ground of want of sanction or no
Yes,
proper
ma'am.
sanction, but also on merits.
My-
Now therefore, he has to be reinstated. No,
My-
and while reinstating, the department while reinstating, you said the court had directed that de novo inquiry, fresh inquiry you must constitute. You did not.
My lord.
You waited, and then the conviction has been set aside. Why would he not be entitled for everything?
My lord, kindly see that two aspects are there, my lord. First principle is that, my lord,
The reason, no principle.
My
The principle is
2008
that despite the order passed by this court, you did not even initiate an inquiry.
my lord.
Then
My thing is that, my lord, we feel for a moment that, yes, there is an interference required for the purpose of, my lord, based on conviction, that termination will go. Quite right, man. My lord, 2013, this secretary was granted. He approached before this on 2016. That is his on part of default, my lord, 3 years. First point. Second point, my lord, in paragraph 25, my lord,
the man is dead now. We can't ask him to come back from heaven.
my lord, the second aspect of the matter, lordship, kindly see that so far relief number 1 is concerned, my lord. My lord, it was already decided by this honorable court by way of read petition number, my lord, 4109/2000. It is reflected in the impugn order, page 54. Kindly see page 54 moment. And even it was not prayed for, my lord, in the read petition.
It doesn't matter.
My lord, kindly see page 54, column 2.
Internal page of,
My lord, page 54 of the impugn order.
no, internal page of the.
My lord, is a part of, my lord, the continuance, my lord, page 54. Impugn order, column 2. Page 54, column 2, being agreed, the original petition SL the said order dated 15/2000 before this court by way of
Reading?
my lord, page 54 of the impugn order. And internal page, my lord, it is page 3, my lord.
Internal page 3.
Yes, impugn order.
Hmm.
Column 2, my lord.
Hmm.
Being agreed, the original petition SL the said order dated 15/2000
We are page
before
three.
this
That's page
court by
three.
way of institute.
We are at internal page 3 of the judgment. Where are you reading?
My lord, column 2, my lord,
Column
first is
two.
original petition.
Number 2.
Number 2,
Being
my lord.
agreed.
Being agreed, the original petition SL the said order dated 15/2000 before this court by way of instituting WPC number 4109/2004. This court by order dated 24/1/2002 on considering the issue arising in the matter proceeded to dispose of the writ petition directing the respondent authority to consider the representation as preferred by the original petitioner against the order of this dismissal from service. In terms of the direction as passed by this court, the Secretary Government House aggregated by order dated 13/5/2002 on consideration of the representation submitted by the provision of section 9. Rules was not complied with, held that the order of the dismissal passed by the authority of the corporation in respect of the original petition heading was bad in law and not sustained. My lord, thereafter, my lord, can you see paragraph 5, in pursuant to the said order dated 13/5/2000, the managing director of the Court of High order dated 31/5/2000 proceeded to reinstate the original petitioner. Therefore, this issue has already been adjudicated in WPC number so and so. But despite of that, my lord, overreaching that findings, my lord.
I am not
There-
able to follow your argument.
My thing is that, my lord, this issue has already been dealt with. About that period, my lord.
Hmm.
There is adjudication. Reinstate was done. But despite of that, my lord, the relief was granted from the period 1990 to 2002. Relief number 1, my lord. And apart from, my lord, can you see it is settled principle law. If it has not been
Just a
treated,
minute. It was directed that the original petitioner be reinstated in the service with immediate effect, subject to the condition that the period of dismissal shall be fixed. And
and lordship in page 6, my lord, the internal page 17, the relief was granted. And lordship, it is settled principle. If it has not been chosen, my lord, by
you say everything is settled, but what you're trying to say, I mean, that if we accept it, the principals would be unsettled. Now the condition that is period of dismissal shall be treated as suspension.
Yes,
There is a conjunction after that.
my lord.
And de novo proceeding shall be initiated. This is for the purposes of facilitating the commencement of domestic inquiry.
My lord.
You don't do that.
Yes, my lord.
Then
My lord, so far our inquiry part is concerned, we feel, man, there is no doubt to that, it is a part of record, but question is that, my lord, it is settled principle, if they are not choosing, my lord.
what settled principle are you
My
trying
lord,
to tell us?
My lord, if suppose it has not been prayed for, my lord, in their writ petition, there is no such
That-
prayer.
We said no in one line. The court can always mold the relief.
Absolutely, my
226 is
lord,
a
but
big,
question- My lord, kindly see, first principle is that, my lord, it is in paragraph 25, my lord, it is decided by the learned single that there is no error on our part. If suppose there is no error or back wages, they are not entitled. Yes, my lord, they can entitle all the thing which is, my lord, post termination, my lord, after retirement, everything, my lord, they entitled, we are ready to pay, my lord. But, my lord, back wages without, my lord, doing any work.
Then in this case, back wages, you have to pay, no?
From
The reason
99,
is
my
this,
lord.
that you kept him out. Ultimately, it was found that your departmental proceeding also failed.
My lord,
The criminal case also failed.
my lord,
Why should he not be paid?
my lord,
Here, the principle of no work, no pay will not apply.
my
Oh,
my lord, kindly see,
everything has been
my
found to
lord,
be wrong.
from 99, my lord, how is he entitled, my lord, till, my lord, my lord, last date of his retirement, my lord.
Yes, because everything was found
What
to
is
be
our
bad.
fault, my lord? Because his conviction, my lord, we have terminated.
Normally, these principles are invoked when, say, because of misreading of something
Mal-
or departmental proceeding, everything goes, no.
My lord,
You yourself reinstated him,
my lord,
not on the orders of the court.
my lord,
You found that the superior authority found that he was wrongly terminated from service. Correct?
my lord,
So you did it.
my lord.
The court only said that you do it. You keep that period under suspension, treat it as suspension period, and de novo inquiry. You just sit tight over the matter. Then you waited for the criminal case. Criminal case, there was conviction without appeal. Says sanction is bad.
No.
Sanction is defective. On merits also, no case.
My lord,
Then why should? And in the meantime, he dies.
my lord, in 99, my lord, 2002, it would have been, my lord,
Give us any judgment in this case that under such circumstances, no work means no pay.
my lord,
We can't. We can't stop the family from recovering this thing.
my lord, we are ready to pay to the past part, my lord, but the post part, my lord, of the service, my lord, benefit. But question is that, my lord, here is a case, my lord, it is the decision of the learned signature itself. Because lordship now just see whether there is privacy or not, my lord, in this imping order.
That is why we said no. You miss out on
My lord,
and start a de novo inquiry. You choose not to do that. Then
my lord,
that period should not be.
my lord, it is,
Suppose you had not suppose the man would not have died,
my lord,
right? He would have lived till his date of retirement,
my lord,
and you would not have started an inquiry,
my lord,
and criminal case ended in acquittal.
acquittal,
Then you'd have kept him under suspension.
my lord,
You would not have kept him under suspension.
that period, my lord. My lord, my only limb of argument is that, my lord, so far, my lord, the decision is concerned, my lord. A decision is contrary to the findings of paragraph 25, my lord. Because, my lord, if there is no error, it is decided by the learned single that there is no error on the part of the employer, my lord. The employee cannot claim, my lord, without doing work, my lord. He is entitled to get the, my lord, all back wages, my lord.
Take it. We have heard Mr. S. Shamaria, learned advocate for the appellant / Assam Seeds Corporation Limited. They respond number 1 or 2?
My lord, one, my lord. One.
One. They respond number 1.
My lord, the original respondent has passed away, my lord. So these are the legal names.
Asleep. So, what was his name?
Hafizur Rahman.
Huh?
Habibur Rahman. Habibur Rahman.
Next. One, Habibur Rahman, an employee of the appellant, on an allegation of misappropriation of funds of the corporation, was suspended and ultimately dismissed from service by the order dated 25/1/2000. The challenge to such order of dismissal resulted in a direction to him, resulted in a direction to the appellant to consider the employee's representation. The departmental authorities, pursuant to such a direction by the High Court, found that the departmental proceedings did not take into account the procedure prescribed under Rule 9 of the Rules of 1964, and hence found the dismissal of the employee to be bad in the eyes of law. Thus, he was reinstated in service with the caveat that the period that from the date of his dismissal till such reinstatement, he shall be deemed to be under suspension and को underline करना, and a de novo proceeding against him shall be started. No such proceeding was commenced. Stop. In the meantime, in the criminal case lodged against him under the provisions of the Prevention of Corruption Act 1984, the employee was convicted and sentenced. Stop. In appeal, the conviction was set aside, both on merits as also on the ground of the sanction to prosecute being defective. The employee had to be reinstated. However, before that, he died. But in the present proceedings, but in the writ proceedings, had to be reinstated. When no order was forthcoming from the appellant / corporation, the employee had preferred a writ petition before this court. But before the same could have been argued, he died. Semicolon, whereafter his heirs were substituted in the writ petition. Recording all these sequence of events, the learned single judge observed that the only sequitur to these concatenation of events would require the heirs of the employee to be paid the entire salary of the employee till the time he retired, and also the pensionary benefits.
Pension we don't have.
Pensionary benefits, if permissible under law. If permissible under law. The challenge of Mr. Chamaria principally is on the ground that while the employee was reinstated in service, it was held that the period during which he was under the period intervening between his suspension and dismissal be treated as period of pension, a period of suspension, the learned single judge has directed for payment of the entire salary of the employee to his heirs. What Mr. Chamaria has missed out is that the concerned period was directed to be treated as period of suspension for the employee, but with the rider that the departmental proceeding would be initiated de novo, which, as noted earlier, never commenced. In that view of the matter, the learned single judge was not of the perpendicular off the line, in directing for payment of the salary for the entire period. We do not find any folly with the judgment of the learned single judge for us to interfere on any count. The appeal has no merits. The same is dismissed.
Item 19.
Well, well, do we have preferred the appeal against the order dated 29/10/25 well? But you will find the order at page 145.
1 second, Mr. Nag.
Malo.
1 second.
Lordship.
It's by judgment here. Oh shit. Not for एक second. इसका कोई मतलब है? No. दोनों चीज. Has the inquiry been concluded?
No, well, subsequently, when the inquiry officer was appointed, it was challenged before the learned single judge by filing another writ petition. There, a stay order has been passed.
Yes, Mr. Chaudhary.
Yes.
Now, what we propose to do is this.
Yes.
Of course, subject to how you mold your argument.
Yes.
We are saying that this departmental proceeding must continue. These observations shall not be construed either against you or in your favor, and let the departmental proceeding be concluded within a time limit.
But no, my lord, that stage is
Because
over.
paragraph 33 means nothing. Paragraph 33, your petition appears to have been allowed.
Yes.
Then it should have been allowed, it should have been post. Paragraph 34
No, my
should
lord.
not have been in.
No, my lord. After having made the observation in para 33, the learned single judge did not set aside the departmental proceeding. It was rightly did so, my lord. For example, it is
in our estimation, this was not.
Then lordship will do that today.
No, this was not the correct way of
No,
control.
my lord. No. My lord,
See, the moment it is found that it is unfair and unjustified, it should be stopped there and then.
No.
The curtain should
In
be
fact, my lord, please come to para 34. Whether learned single judge has done that or not. I'll come to my other argument. Please come to that judgment, my lord. Impugn judgment at page number 155.
Tell us the internal page. We have the judgment at a different.
Or page 12. Now, the learned single judge notes that the criminal case and the departmental proceeding were grounded on the same facts. same set of
The learned
witnesses.
single judge did not know, the learned single judge was told.
No, my lord, the materials are before the court.
How a judge would know? He would only be told.
Yes.
He appreciates the,
Yes. I'm sorry. madam.
knowing
Yes.
his personal knowledge.
Yes, yes. So it was the learned single judge, based on the record, came to the conclusion at para 33 that in such a situation, the continuance of the proceeding would be a nullity. So having said so, what does he say in para 34? Please come to it. Accordingly, this court deems appropriate to dispose of the writ petition by directing the respondent authorities to conclude the departmental proceeding which is pending against the petitioner in accordance with law, by keeping in mind the observations made herein above in the period of 1 month.
Suppose,
Now, my lord, kindly see.
all right,
Then what they did, my lord, what the state did, they filed an application seeking extension of time. Now, kindly now see the observation of the learned single judge, then it will absolutely clear. Ah. Okay. No, read order to 19. Please come to page 193.
tell us the internal page.
Yes, my lord. No, that will be a separate, my lord.
Page?
Page number 193. Now, despite the clear observation of the learned single judge, whereby 1 month was given, they filed an application seeking extension of time. Now, this is what the learned single judge observed at page 193, the last but one para. Today, when the matter was called for, D. Nat Learned Senior Government Advocate submits on instruction that a further period of 3 months would be required to conclude the departmental proceeding. It appears that departmental proceeding against the respondent is pending for a long time, despite conclusion of the criminal trial, resulting in acquittal of the respondent. In the considered opinion of this court, the further period of 3 months in the context of the present case appears to be unreasonable, and as such direct respondent to conclude the departmental proceeding as directed earlier by this court, strictly in a period of 1 month from today, failing which adverse consequences in law, if required, be faced with. So, my lord, the learned single judge, while passing this order, referred to the earlier order. Now, my lord, let us come to the other aspect of the law. Now, why learned single judge passed this order? My lord, what I would like to submit for your lordship's kind consideration is very simple, my lord. As a proposition of law, there is no dispute that there could be simultaneously a criminal case and a DP. There is no dispute on that. But certain exceptions has been carved out. In 2 of the judgment of the Supreme Court, we find, my lord, the exception has been carved out. What is that, my lord?
GM Tang.
GM Tang, and prior to that, Paul Anthony.
Paul Anthony is old, GM Tang.
GM Tang. No, my lord, Paul Anthony is more specific. I'll place the facts of Paul Anthony and the finding, and this case, lordship will find it is absolutely significant. Now, my lord, there it was said that if the charges, which is a part of the criminal case, forms the basis of the charge in the DP, same set of witnesses are sought to be relied upon, and the charges of grave
No, that's
nature,
right. That
that once there is an acquittal in the criminal case, then there cannot be a DP. Now, in fact, my lord, in Paul Anthony and GM Tang, in the departmental proceeding, they were dismissed. Writ petitions filed, dismissed. Division bench affirmed. Then, my lord, at a later stage, when they got acquittal in the criminal case, then they approached the court. Now, kindly come to Paul Anthony, my lord. It's very clear in my humble submission. Please have 1999 3 SCC 679. But for the judgment, the learned single judge is wrong. But for if these principles are rightly applied, lordships will affirm this order.
He should have done that there and then.
My lord.
He should have done that there and then. Why relegate it to the authorities to close it?
So relegated to the authority
why?
to formally close it.
Now why formally close it? If this is so, the entire continuance of the disciplinary proceeding was bad.
No, now lordship is sitting in appeal, continuation of the same proceeding. Lordships can do it today. If I can persuade your lordships to do that. Please come to me, Lord, paragraph.
This only, paves a way for the other side to file an appeal, no? don't pass an order like this. Suppose a criminal case is being tried. The person is convicted.
People will grow.
Appeal we hear. and we
Nowadays,
found- we find that
nowadays you often come across an ad, my lord, grow. People are growing, my lord, they'll grow. Please come to me, Lord, para 3, 4, and 5 for the facts. Please come to page 685.
बहुत clear है. Is second doctor is given. What? Mr. Nath, I'll have to proceed in another way. Look at this. We would not have passed this order.
But I have one submission.
No. First hear us.
Lordship.
But we don't find the judgment of the single judge to be perverse or so bad so as to
Yes.
is appeal में अभी नहीं देखी.
But I have one submission. Kindly permit me, Lordship, may kindly see.
It's an
one
unhappy
aspect-
way of putting the denouement of concluding it.
Yes.
Which was not required. You should not have been given an opportunity. If the court was so sanguine, the curtains could have been drawn on that date.
Well, in fact,
In fact, that is your only argument. 33 and 34 don't collocate.
my submission is page 95.
No, if we had found anything, let me tell you frankly, if we had found any perversity in the judgment, we would have certainly interfered because of 34, 35.
Yes, but there is
So
no.
otherwise, we are not finding anything. He discusses the criminal charge, he discusses the domestic inquiry charge, and then makes a comparison, gives a tabular form, all the effort. Now sitting in appeal, we are this appellate jurisdiction is not like regular
My lord,
appeal.
I would humbly submit, my lord, that the
Can
learned
we
single
say that
judge.
this order is? Can we say that this order is perverse?
Yes, my lord, because the learned single judge has missed one thing.
Sans 34 and 35.
My lord, the learned single judge has, my lord, in the entire judgment, lordship will not find that the petitioner, the respondent was acquitted on benefit of doubt. That aspect has not been dealt with in the,
No, that is
in the
also
entire
wrong.
judgment. My lord, page
Absolutely
95.
wrong.
Kindly see page 95 of the appeal memo.
No, please read para 47, then you come. Kindly see that demand was made, that itself was not.
Let me make my submission. Let me make my
It was
submission.
on my leg, that's why I say.
Page 95 of the appeal memo.
Page
95. This aspect was not at all considered. He was granted given benefit of doubt. Acquittal is not honorable acquittal. GM tank and everything is on honorable acquittal.
No.
I'll make my submission, Pula. Page 95 is the order.
Page 95, what are you trying to show?
Well, this is the order judgment in dated 19/7/2023 in the special case where the petitioner was acquitted. Kindly see, the prosecution has failed to establish the charges framed against the accused under section so and so beyond all reasonable doubt. So the accused deserves benefit of doubt, and hence the accused is acquitted of the charges framed under section so and so on benefit of doubt, and he is set at liberty. So benefit of doubt has not been discussed, not is been considered in the entire judgment. When the accused is acquitted on benefit of doubt, then the things that is therefore para 33 doesn't come. In the entire judgment, if lordship kindly see, kindly see para what is their case. The case projected before the learned single judge, if kindly take up the impugned judgment, para 9, that is the simple case. Para 9 of the impugned judgment, internal page is page 147. That is their case, that I have been acquitted. So now you reinstate me. So this was the projected case, and I'll the representation annexure K to the writ petition. That is their case, Lord. How the litigation started, kindly see. For a moment.
Now, the trial court may have said so in the last part that it is benefit of doubt, but look at paragraph 48 of the judgment.
47 and 48, Milord.
Well, Lordship, may kindly permit me, Milord, I'll just come to that. Before that, kindly come to page 130. This is the representation after acquittal. The page 30 annexure K to the writ petition. This is the representation he filed after acquittal before the authority.
Page
That-
page 130.
130 of the appeal memo. This is the representation. He said that I have been acquitted. The second parabola of the representation can you see? This was to the principal secretary. As per judgment, I have been acquitted of all charges in the above referred registered case number so and so. Consequently, the departmental proceeding initiated against me by later mentioned in reference number 2 under rule 9 of the so and so are no longer applicable. In the light of the honorable special court judgment, I kindly request the department to drop the departmental proceeding against me. Furthermore, I would like to appeal for consideration of promotion and etc. etc. So this is the case. Then Milord, kindly come to page 147 of the impugn order. 147 para 9. That is the projection before the learned single judge. He accordingly submits that the departmental proceeding on the criminal case being based on identical and similar set of facts and wherein the criminal court having acquitted the petitioner from the charges level therein, it would be unjust and unfair to continue the departmental proceeding against the petitioner on the same set of allegation. So that is the projection. And in the entire, then Milord, GM Tank has been referred. And kindly come to para 28 of the judgment. 27, Milord. 27, 28, Milord. Kindly see, Milord. Then para 27, page 152, Milord. It further appears that the criminal court, upon considering the testimonies of the witnesses, which are also being relied by the inquiry officer in the departmental proceeding, was pleased to hold that no charge of accepting the illegal gratification was made out against the petitioner. Apt to refer the decision of the apex court in the case of GM Tank. Then Milord, GM Tank para 30 and 31. Those were quoted. And finally, Milord, para 30. Para 30, reading the aforesaid judgment, it appears that in a given case where the charges, evidences, witnesses, and circumstances are one and the same, and the criminal court, after conclusion of trial, acquits the accused delinquent against the officer so alleged, findings recorded in the departmental proceeding, if allowed to stand, shall be unjust, unfair, and oppressive. In other words, in the event the facts and evidence of in the department as well as the criminal proceeding, if it is one and the same, without there being any iota of difference, and acquittal in the criminal proceeding shall have a vital bearing in the outcome of the departmental proceeding. In such event, continuation of the criminal proceeding on the basis of similar set of allegations and witnesses is not justified, and the same shall be unfair and oppressive to the delinquent accused. There is no quarrel to the proposition. Then para 33 he has noted. But we filed the IA. Well, specifically what we have prayed before the learned single judge, Lord, IA we have annexed the relevant paragraph 8. Kindly come to page 167. Well, in the entire judgment, Lordship will not find that the benefit of doubt has been mentioned at any place, Lord. Para 8, this was our prayer before the learned single judge in the IA. The applicants respectfully state that great irreparable loss and injury would be caused, as Lordship got, Lord, page 167. If the extension of 3 months' time as prayed for to complete the departmental inquiry against the opposite party is not granted, inasmuch as the departmental authority is required to appoint a new inquiry officer to continue with the inquiry, and the applicants are committed to undertake and complete the inquiry as per rules. So we have prayed for 3 months' time to complete the inquiry as per rules. Then after considering that, what the learned single judge has said, page 191, the order starts. If kindly come to next page, internal page 3 of that order dated 9/1/25. The para starts from, it appears from the averment made in the application that the state government is unable to conclude the departmental proceeding within the time period granted by this court earlier, and accordingly has filed this application seeking extension of further 3 months' time to conclude the departmental proceeding on the grounds stated in the interlocutory application. Pertinent to refer to para 33 and 34 of the judgment and order dated 29/10/2024 passed by this court as follows. 33 and 34 quoted. Then the learned single judge said, a perusal of the aforesaid paragraphs indicates that though the criminal court has acquitted the respondent for the same set of charges, the departmental proceeding has not been concluded by the state government, and accordingly this court directed the state government to conclude the departmental proceeding, which is pending against the respondent. in accordance with law by keeping in mind the observations made in the preceding paragraph of the said judgment. So, and within the period of 1 month from the date of receipt of the certified copy of the order. So the limitation has been given to the authority to conclude the departmental proceeding, means to drop the departmental proceeding on the as per observation made in para 33 and 34. The aspect of benefit of doubt, the acquittal of the petitioner on the benefit of doubt has not been ever considered. So this is lordship will see whether this is a case of no evidence or this is a case of benefit of doubt. If it is a case of benefit of doubt,
Mr. Nath, your arguments would have been more weighty. It would have been more weighty if the learned single judge would not have copied paragraph 47 of the criminal code judge. Now, the moment that is there, your argument, vanishes into thin air. I should not be so strongly saying this, but then this argument cannot be taken to any logical conclusion for the reason presently. We are not happy with the conclusion. The demand of bribe payment, all right, it's very difficult to prove, but then the departmental proceeding ought to have been allowed to be continued. Correct. But a comparison of the criminal charge and the charge in the departmental proceeding are, to use the words of the Supreme Court, there is not an iota of difference. That's our difficulty, number one. And number two, despite that, no need to go into it. There should not have been any haste in concluding the departmental inquiry. This is our positive feeling. But then we are also concerned about the basic, principle governing our appellate jurisdiction here in writ appeals.
But
not every case, not for any line can we interfere. That's the whole ground. Now, GM Tank has not been undone up till now.
True.
Right.
True.
The judge makes a comparison. There is no hurried way. If he were doing it, he should not have been so cautious in asking the authority, the departmental, the inquiring authority to conclude it. He could have concluded it there and then. This is one. But then he makes all the efforts of quoting the paragraph. Therefore, Mr. Nath, you cannot say that the issue of acquittal, honorable acquittal or benefit of doubt has not been dealt with. He quotes it, though he doesn't say in so many words, but he quotes it. And then the last part of the judgment, which says benefit of doubt, it means nothing. It says it could not prove, the prosecution could not prove the case beyond doubt. Beyond doubt and benefit of doubt are not proving beyond doubt and benefit of doubt. These are two different things with a subtle distinction. Every case, every criminal case, therefore, is decided on the prosecution not proving its case. Right. And benefit of doubt is that, something is leaning in favor of the prosecution also, but primacy has to be given to the materials in favor of the accused. Said benefit of doubt has to be given. He may or he may not have done. So this is not the final import of the judgment in the trial court. He says in paragraph 47 that the prosecution could not prove, failed to prove. You made your argument is not baseless. I agree. If it would not, but he quotes it. No, that's the whole difficulty. But he says, after carefully scanning the evidences on records, it's safely concluded that the prosecution has failed to establish. Now, where is the benefit of doubt here? Where is the benefit of doubt here? It's an honorable acquittal.
But the order I have placed.
Had he not quoted, we would have taken your ground. See, we are only, how many times do you want to tell us? We would not have decided this way. No hurry.
The appeal, rather the learned single judge has observed that there is no appeal filed against the acquittal, and that I have said that appeal has been filed, condonation notice has been issued, that is pending. I have annexed the order. It is also there. That I have annexed. So the order stands, my lord. That
where you should have done that before. No appeal. Where is the appeal?
204 page, no? Page number 204.
Where is that appeal pending?
No, the IA criminal before the IA in the condonation petition notice has been served.
It'll take years and years and years.
No, it has been served in the month of August 2025. Notice has been served on the respondent. notice was served.
If he's convicted, remove him from service. If you are able to get the judgment of the single judge, judgment of the trial court upturned, remove him from service. But how can we disregard the law and the established position? We are not happy. A person demanding bribe, there should not be any hurry to reinstate.
So,
But there has to be an explanation. No, we can't just pass an order because we think it otherwise.
Therefore, when the learned single judge, we said that that is why we are before your lordship, that when the person has been acquitted, the order stands the benefit of doubt, on benefit of doubt he has been acquitted. And therefore, we want to conclude the departmental proceeding as per rules by appointing the inquiry officer. In fact, the observations are in a manner in such that the department cannot proceed with the inquiry. And in fact, while passing the order in the IA, that has been clarified, reiterated again, that with the observations only we have to proceed. And that is why we are before your lordship. So our
We have heard Mr. Dina. Difficult. In fact, you are in contempt today. It's not your contempt today.
Lord, we are before your lordship, my lord.
If we don't interfere with this, then even if, you are in contempt. Second time an order has been passed.
1 month time has been given to complete the inquiry. We prefer the appeal, my lord, because lordship has seen. Lordship has seen.
We will not do that because we will not say anything about that.
Yeah, okay.
Pass an order.
Well,
nothing can be done now. You channelize your energies to the appeal. Get the judgment upturned. For 1 year. The second order passed in miscellaneous case seeking time. This order was passed when?
9/1/25. My lord, we prefer the appeal thereafter.
There was no stay of the order.
No.
There is no stay. We prefer the appeal. There was some delay. Lordship has condoned the delay, my lord. And in
No,
fact,
you're preferring the appeal, but you had to do it, no?
lordship, my lord, in fact, my lord, we have started the process to initiate the departmental proceeding, my lord. To
Anyway,
complete the
let's
departmental
conclude
proceeding.
it now.
Lordship.
We have heard Mr. D. Nath, learned government advocate, learned senior government advocate for the appellant state, and Mr. Ken Chaudhary, learned senior advocate for the respondent. The respondent, while serving as chief executive officer at Darang Zilla Parishad, was arrested and subjected to a criminal trial under various provisions of the Prevention of Corruption Act 1988. He was also proceeded against departmentally. Wherein the statement of allegation were found to be exactly similar to the charge in the criminal case. The criminal case ended in acquittal of the respondent, with the trial court observing that the prosecution had completely failed to establish, had failed to establish that the accused respondent had demanded illegal gratification from the complainant, from one Saidur Rahman, with a promise that he would allot Bessimari markets to him. It was also observed by the trial court that the allegation of acceptance of illegal gratification by the respondent from the informant was also not proved beyond all reasonable doubts. Under such circumstances, the trial court found it safe to hold that the prosecution was unable to establish the charge framed against the respondent under section 17/13 bracket 2 of the PC Act 1988 beyond all reasonable doubts, and that the respondent deserved the benefit of doubt. Close to the heels of this judgment, the respondent came up before this court seeking discontinuance of the departmental proceeding against him in the event of such acquittal on merits. Though the use of the phrase benefit of doubt was used at several places in the trial court judgment. The learned single judge, after analyzing the statement of allegation in the departmental proceeding and the charge sheet in the criminal case, recorded a finding that there was not an iota of evidence, that there was not an iota of difference between the two, and held that in such case, continuance of the departmental proceeding against the employee would be unfair and unreasonable too. Relying heavily on Captain M. Paul Anthony versus Bharat Gold Mines Limited and another, 1999 3 SCC 679, and GM Tank versus State of Gujarat and others, 2006 5 SCC 446. The learned single judge recorded his finding in paragraph 33 of the judgment impugned, which we are extracting for the sake of completeness. After having said so, the learned single judge proceeded to direct the disciplinary authority, direct the inquiring authority to conclude the departmental proceedings pending against the respondent in accordance with law, keeping in mind the observations made in the judgment, within a period of 1 month from the date of receipt of the certified copy of the order passed by the court. To stop. An attempt by the state/appellant to have the time limit extended was refused, but 1 month further time was granted to conclude the proceedings on 9/1/2023. Hence the appeal. We are at a loss to understand as to why the matter was relegated to the inquiry authority when the learned single judge, on an analysis and comparison of the statement of allegation in the departmental proceeding and the charge sheet in the criminal case, were, what did I say? they found that they were one and same, and that the continuance that any continuance of the departmental proceeding would be unfair. Nonetheless, with such clear observation, the curtain ought to have been dropped then. Nonetheless, it was directed, as noted above, that aligning with the observations made by the learned single judge, the inquiring authority should conclude the proceedings, which somehow or the other has not yet been concluded. Not yet been concluded. While challenging the aforenoted judgment, Mr. Nath has made twofold arguments, namely that the learned single judge did not truly appreciate that the acquittal was that the acquittal of the respondent was not earned on merits, but on benefit of doubt, such an acquittal, such a judgment of acquittal was made. And that mere comparison of the statement of allegation in the departmental proceeding and charge sheet was not sufficient to come to the conclusion that there was not an iota of difference between the two, thus triggering the application of GM Tank Supra. He further submitted that an appeal against the judgment of acquittal has also been filed. And in such an event, the learned single judge ought not to have given such a short time limit to conclude the proceedings against the respondent, which actually meant discontinuance of the proceedings. Discontinuance of the proceedings. Mr. Nath has also taken us to the last part of the judgment of the trial court, wherein it has been observed that the respondent has been given the benefit of doubt on going through various paragraphs of the judgment of the trial court. We are of the view that the acquittal was on merits, as the prosecution could not prove the case on all aspects of the charge, on all important aspects of the charges, namely the demand on an important aspect of the charge, namely the demand of the bribe money. That apart, we have found that the learned single judge has not only made comparison between the statement of allegation and the charge sheet, but has also examined the list of witnesses and documents relied upon by the trial court, as also the inquiring authority. Under such circumstances, we do not find any fault with the judgment, when the learned single judge rejected the proposed distinction between the departmental and criminal proceedings on the basis of approach and burden of proof, which in our burden of proof. Most of that apart, since we have not found any serious vulnerability in the judgment, comma, we do not wish to interfere with the same. For the aforementioned reasons, we dismiss the appeal with the direction to the state to have the judgment of the learned single judge complied with. Complied with a statute.
Well, the observations made will not affect the criminal appeal, my lord.
No, we cannot. Oh, no, that is something different. That we should not even enter in.
That's it.
He cannot even argue.
My lord.
Item 20.
Forest division matter, my lord, they have filed already, they have filed their affidavit, my lord, that is filed on 12/11/2025.
Regarding working plan of forest divisions,
Forest division.
there is a direction from your lordship on 37/2025 to file an affidavit bringing on record the steps taken. But under the government of Assam, there are total 21 forest divisions.
That we have noted in our order.
Yes, that affidavit you have filed, my lord.
No others. How about BTC and Dima Hazao? You have filed.
BTC?
The working plan has been formulated. You're suffering from cold, or it is just to avoid. So process is going on how long? Which is the other body? Which is the other?
Other, my lord, autonomous council, my lord, that is Karbi Anglong Autonomous Council, and in aspect of the
You
other,
are
my lord.
appearing for Karbi Anglong. You are appearing for? You have also filed your affidavit. Stating same thing, that it is yet to be formulated. Yes is not satisfactory. You intimate to us about the stand of the government.
If I may indicate something. Actually, what has happened, my lord, there are so many stages. And the final stage, my lord, lies with the my lord, Ministry of Environment and Forest, Climate Change, my lord, Government of India, my lord, regional office is at Shillong. Most of the plans are pending there, my lord. In fact, in respect of the state of Assam, my lord.
Then you say that we will issue notice to the.
They are already a party,
state
my
of
lord.
Meghalaya.
They are already a party, my lord. That's point number 3.
Who appears for Union of India? What have you said?
What have you said?
No. Union of India?
Who appears for state of Meghalaya?
No, it's a.
It's not a
It's
party.
not Meghalaya.
Meghalaya is
It's
not a
in
party
Assam.
because it's a central government agency at Shillong, my lord.
Office is at-
Office at Shillong, my lord. 4 of our proposals are at their stage, my lord.
Mr. Goswami, you tell us what is the stage on the next date. We will then issue necessary.
Yes, ma'am. Yes. And
Right.
if I may submit, my lord, in fact, my lord, I think, my lord, there should be a judicial order giving a time frame, my lord. Because it is seen, I could see, my lord, it's very, processing is going on very slow, my lord, because
Mr. P. N. Goswami, Learned Additional Advocate General, shall inform this court about the stage at which the working plan for the forests are pending. A formulation of working plan for the forests are pending. whereafter we will take necessary steps for, we will take necessary steps for, whereafter we will pass necessary orders for implementation of those working plans. Re-notify. Give a 2 pages affidavit.
My lord.
in this case. Then we record it and then we issue directions to the union government.
In this affidavit, we have indicated 10 are approved, 11 are pending, 4 are there.
That we have
Yes.
put it in our.
Yes,
earlier
earlier order it was noted, madam. I'll bring on record updated status, madam. If necessary, madam, there should be timeline for the authorities, madam.
That day we will say that.
Yes, but they're
First you-
moving very slow.
Put it on record, then we'll do it.
T.N. Godavaram judgment madam, order was of 1998, to be formulated in 2 months. Now we are in 2026.
Yes.
20 March,
Obliged.
2020. Item 24,
Yes, Mr. Das.
Yes, my lord. This is basically pay fixation matter.
No,
Pay
pay fixation.
pay
all right.
fixation and
Why
revision.
should the special pay, what is that? Principal seat pay be incorporated in the basic pay? That's the issue decided, no?
So basic issue is whether, because how the pay is to be revised and pay is to be fixed in the stenographer grade 1. Whether, because we have done this done it as per the advice of the finance department. So finance department has said that we have to follow rule 11. Whether there was any infirmity on our part in following rule 11 or not, that is the issue, my lord. Whether PSP will be added or not, that's a different thing altogether.
So, I will. Okay. Notice, readings complete.
Pleadings complete, my lord.
Who appears for the other side?
She is there.
All are ready. They have not been able to see. So they can, the judgment, you just tell us the summary of the judgment where it hurts.
Yes, ma'am. Yes. Because, my lord, if your lordships kindly appreciate, is very,
We
he
have
was,
been able to understand this judgment.
my lord, judgment is a bit, because it gone far away from the rules, my lord.
Therefore, we got lost in the maze of.
My lord, I'll assist your lordships, my lord. I'll assist, my lord. Because,
Give us a short note, five
fine,
pager,
fine, my lord.
with clarity. Don't just quote from the judgment.
No, my lord. I'll,
Because the judgment goes here and there.
my lord, I'll just simply explain for your lordship's assistance.
Do it after you formulate your 5 pages note.
Fine, my lord. Fine.
It
12
will be
feet.
lesser, but not more.
My lord, I'll try to be lesser.
Okay, let this matter come up for consideration on
12 February.
12 February.
which date?
12 February.
12 Thursday.
12 February.
My lord, can it be Thursday? Can
let's
it be
keep
any
it
other day than Thursday?
Let's keep it 19.
19 also Thursday, my lord.
19th of February. You don't want it on Thursday.
My lord, any other day than Thursday, my lord.
Okay.
20th.
28th, my lord. Fine, my lord. Fine.
20.
Highly obliged.
Give us a note before that. So that
Yes,
we
my lord.
don't.
I'll give it before that, my lord. Basically, my lord,
No, basically, I understand. I think the basic issue is that the learned single just says that the principal seat pay should be included as the basic pay.
it's not required because while
That's the decision.
yes, while we fix the pay,
And prima facie, we are not agreeable to it. Because that is an additional thing.
that is an additional thing.
That is our case.
So first we have to,
Therefore, we said, but the reasoning we could not decipher.
Learned Single just read down without any challenge, set aside a communication which was never challenged, my lord. That highly obliged, my lord.
Item 25 to,
The
sorry.
main effort has to be made by you, respondent number 1. Because prima facie, we are finding it to be unsustainable. Prima facie. Of course, it's a very tentative opinion. We'll see. So get ready.
Basic pay is as per the RTI also.
Basic pay would not include these additional accoutrements.
No,
That's not the principle.
So far as high courts employees are concerned,
Application is there not.
Specific.
no. So far as high courts employees are concerned, their basic pay shall be calculated
on the basis of pay in the pay band, grade pay plus PSP.
It
But
says so.
yes, it is there, but PSP has already been fixed. It is not to be revised. PSP,
Acha, acha.
No, no, the definition, existing
Anyway, on to
agreement.
next date. Let us not
I'll-
waste time over.
Okay, fine, well, much.
Item 25 to 27.
Yes, Mr. Advocate General. you have
Lordship,
this-
I have filed the affidavit.
Yes.
If Lordship is pleased to look at paragraph 6 of the affidavit, that says everything, Lord.
The last of the affidavits.
Yes, last affidavit.
Page 172, my one.
It will be in 173, Lordship will find paragraph 6. Or something.
We highly appreciate such clear, formulation of your plan. We highly appreciate it. This is the way affidavits have to be. This is the way we want the affidavits from the parties to come. You have put it on us. That's true. But then you have explained your.
Last time, your lordship asked him, then your lordship asked him to put in writing, my.
No, I'm saying something different.
Yes, that's why, ma'am.
Chaudhary, I'm saying different. I mean,
I would
Mr.
appreciate-
He has understood. He has thrown the blame on us. Nonetheless, with a good reasoning.
Because
concluded.
identical situations are prevailing in 2-3 other medical.
No,
hospitals.
correct,
That is the reason, Lord.
Correct. We will.
Yes.
Yes.
we will-
Only because of that MOU, the condition between state of Assam and the.
You have said so
Yes.
very clearly.
Yes.
That's.
Said so very clearly. We will also try and put it in a proper way so that we would also put it in a way in which it
Lordship.
is not misused by others.
Absolutely, Lord.
मेरा judgment, man. Allow it. Pursuant to the orders dated 15/9/2025 and 18/11/2025. A reconsideration about the cases of the appellants were made, especially in view of an undertaking, especially in view of the undertaking / commitment by the state government in the memorandum of understanding between the Ministry of Health and Family Welfare, Government of India, and the state of Assam. What have I said? In the affidavit filed by the state on 8/1/2026, it has been clarified that there could be no regularization or regular appointment against sanctioned posts of the appellants, for it would entail practical and administrative difficulties and would also not be in strict consonance with the law of the land. However, the state is willing to consider the engagement of the appellants strictly in accordance with the existing norms applicable to fixed pay employees working in various other departments of the government. In that case, their engagement shall be governed by the prevailing rules applicable to fixed pay employees regarding salary fixation, other related service benefits, and the age of superannuation, which would be 60 years. The state has further clarified through the affidavit that if the appellants are engaged, their services would be utilized within the Health and Family Welfare Department or Medical Education and Research Department or any other department, as may be required from time to time, depending upon administrative exigencies. We need to further specify that such a concession has been made by the state strictly on the ground of the commitment undertaken by the state in the year 2010, as reflected in the Memorandum of Understanding executed between the Ministry of Health and Family Welfare, Government of India, and the Government of Assam for implementation of the National Program for Prevention and Management of Burn Injuries. Burn injury. We appreciate the stand of the state in acknowledging the experience of the appellants and also, as far as possible, respecting the commitment made by Memorandum of Understanding between two entities, which would not only benefit the appellants but would also provide trained workforce in the medical field. With the aforementioned stand of the government, of the state, we close this petition with the expectation that the appellant shall be engaged within a period of 60 days. Within a period of 60 days. Under the terms and conditions specified in the affidavit.
Keep your place.
24,
Please stand.
5, 6, and 7 mile. Total matter 4, 6, total. Your worship.
Sir, all correct, sir.
26 and 27, single person.
All three.
Yes. Total 11, but they have not come, man.
In the common judgment. The appellants we have said. Only the appellants.
Within 40 days, Lordship, because the model code of conduct may come 40 days. Otherwise, it will keep pending for another 3 months.
कोई measurement नहीं है. Within 30 days का ये 1 month or within 1.5 months.
Make it, Lordship will make 45 days.
45 full?
Yes, 1.5 months.
Within 45 days.
Well, single judge, that order maybe not necessary.
This will merge.
We have not decided.
No problem, man, no problem.
We have
I
decided.
appreciate, man, whatever is done, I think is
This
enough.
is more than enough.
Enough,
Mr.
man. Yes, yes, madam.
At
No,
least he is
bless you.
appreciating something, Lordship.
Yes, madam.
My friend is appreciating something.
No. The last time also I appreciated, madam, when we are taken.
No, but don't keep it only for such concessions. You must appreciate other aspects of it.
Yeah, yes.
We have to read between the lines.
Other aspect, my lord.
See, advocates as a body, you must, support each other in all endeavors.
That
I
is
think
there, madam.
only you stand united.
That will be
That
discussed in
that will
the.
make it win-win situation for everyone.
That will
But
be-
if it is not happening, some may win, some may lose.
Yes, yes.
Madam, sometime I may be reasonable, son, he may be reasonable, madam. That we were to go, my lord.
But we have
So
a
he's-
encounter in the coming 2 months.
He has all
Anyway,
these,
let us see.
Mr.
I
AG,
hope
he
we'll-
has all these caveats ready that today I'm, at this moment, I'm reasonable because we have got the concession. Sometimes we will not be able to reasonable. So, yes.
Obliged, my lord.
Item 28,
Highly obliged.
Obliged.
Yeah, let's go.
May I please, your lords?
Mr. Bhattakur, after lunch.
Lords.
Yes, you have any problem?
Same please.
Huh?
Same
item.
This item is actually.
Hold. No, you wanted time or something?
No, Lordship, they were supposed to file the writ. It's okay.
You come back.
Lords.
item 28,
Here, your lordship. In this PIL, your lordship, the petitioner has made a prayer, your lordship, initially for your lordship removing the people who are occupying the protected land under Chapter 10 of Assam Land and Revenue Regulation, your lordship. Now, your lordship, ultimately, if your lordship takes up the order sheet, your lordship, on 9/12/2019, this honorable court has conclusively, your lordship, decided the issue. And then, your lordship, it has recorded, your lordship, the kind of, your lordship, the encroachment that had taken place in the protected land for tribals, your lordship.
9/12?
9/12/2019.
Where do we get it?
It's a long order, your lordship. And the honorable court, after recording,
Just a minute.
Lord.
Just a minute.
lords,
Now, your lordship, the honorable court did not dispose of the matter, kept the matter pending, your lordship, to monitor the implementation of this order, your lordship.
Now, what is your stand? Has it not been implemented?
No, your lordship, let me complete. Then, your lordship, some notices were issued in some of the districts, your lordship. Then they went to the apex court, those affected persons. And the apex court gave directions that individual notices should be given to the people and they should be heard, and thereafter appropriate action may be taken by the authorities. That was the direction, and we don't have any grievance on that, your lordship. We cannot have. And ultimately, your lordship, although that has been issued, but this has not been, your lordship, given effect to this order. Till that, your lordship. Your lordship will find series of affidavits filed by them, your lordship. But in those affidavits, they have been reiterating that they are taking steps, they will do this, do that. Apart from that, there is
But there are no land alienations in these areas.
no, your lordship, these are land alienations. Tribal people's land, your lordship, encroached by non-protected classes of people, your lordship. That's the issue. That's why we have raised this issue. And in fact, your lordship, they by filing an affidavit, your lordship, they have showed the nature of land alienation that had taken place in different tribal belts and blocks, your lordship. These tribal belts and blocks are, your lordship, notified under your some land and revenue regulations.
What do you?
Lordship.
They are protected. Some of the people, those who are.
You
there-
appear for BTC.
No, my lord, I am for the private respondent.
Who are the private respondents here?
My lord, we have been pleaded, my lord.
Who are you?
Those who got the notices.
Those who got the notice,
The land, the non-tribals who have acquired land.
no, my lord, they are there. They are protected under the rule.
Why don't you say who are you?
We are the resident of that area.
They said that, your
Tribal,
lordship,
local or outsiders
My lord, they are non-tribal, but they are resident of that area
from before?
before notification, and they are protected under the, my lord.
then they need not be apprehensive, your lordship. Their rights are protected. Lordship.
Lordship, kindly say, in my affidavit, I have annexed Supreme Court order, my lord. Page 190. Page 190. By regulation one.
No, we need the response of the state.
Lordship, we have filed affidavits, your lordship.
The filing
It is
affidavit
one-
doesn't mean anything to us. You have to tell us what have you filed.
Yes, sir. The latest affidavit was filed on 28th of May 2024, your lordship. There a cumulative chart of the encroached land at the tribal belt and blocks was district-wise were given, your lordship. And the second annexure, those districts where the encroached lands were identified, and those districts, the particular revenue circles where actual encroachment was there. That cumulative chart has also been annexed, your lordship. What has happened, your lordship? The notices were served to the encroachers. Thereafter, they had filed IA in this to be included in this EIL, your lordship. Thereafter, they went to the Honorable Supreme Court, your lordship. There it was, the Honorable Supreme Court held that the deputy commissioners of those concerned districts would give a personal hearing to those people who are claiming to be the residents of that area for from long time, your lordship. So that direction, I have filed the affidavit on behalf of the Revenue Department, your lordship. So that instruction was given to the deputy commissioners of those particular districts, your lordship. So that
That's all right. In case we Mr. Bothakur, we
Lordship.
intend to pass an order. I mean, the
Lordship.
steps are being taken.
Lordship.
We'll say that the government, the respondents are taking steps in accordance with the judgment
Lordship.
passed by this court as also the directions given by the Supreme Court. Now, in case you find any breach, you can file a 2 pages affidavit that will revive this.
Lordship.
We otherwise close this.
My difficulty is, your lordship, is that, your lordship, I don't have any connection with even with the
Forget
client, your
in
lordship.
case you get connected
Lordship.
to anybody who feels aggrieved,
Lordship.
we will revive it.
Lordship.
As of now, we must conclude it. Take this.
And page 192 will be clear.
And in fact,
We
your
are
lordship,
concerned with you, sir.
in
You
fact,
have,
in-
you have already got your protection. There is no difficulty.
in
We
fact,
are
your lordship,
concerned with the objections raised by the writ petitioner.
in fact, your lordship, during one of the hearing, your lordship, another bench, your lordship has asked me to submit a note, your lordship, regarding the measures, further measures that can be taken to, so that no future encroachment taken place. I have also submitted a note also, your lordship, pursuant to that direction.
Lordship, if kindly peruse it.
Now,
Aggrieved by the encroachments made by outsiders in tribal belts and blocks in the state of Assam, which were created in the year 1948 by the government of Assam. The present public interest litigation, PIL petition was filed. Venture this court-wide order dated 9/12/2019 recorded that that a committee was constituted by the government of Assam under the chairmanship of H.S. Brahma, IAS retired, for suggesting measures for the protection of land rights of indigenous people of Assam. The committee submitted its report, pursuant to which necessary changes in the revenue laws were made and notified. The provisions contained in chapter 10 of the regulations of 1886, the state contents is being implemented with full force. Some of the non-tribals,
non-protected class,
some of the non-tribals who were residents of the area were also granted protection pursuant to the orders of the Supreme Court. Some of them have been impeded in this petition. Responsibility has been entrusted upon some of the deputy commissioners to ensure full implementation of chapter 10 of regulation of 1886. By and large, there are no identifiable land alienations because of the proactive steps taken by the government. Thus, we do not find it to be necessitous to continue with this petition any further. However, if any breach in that commitment of the state is noticed, it would be open for the petitioner to file a 2 pages affidavit which would revive this petition.
Only your lordship, that observation that no alienation had taken place identified.
By and large, we have said.
Lordship, because your lordship affidavit says, your lordship, that there is a large scale alienation of land had taken place.
By and large, no. We hope and expect that the identified encroachers would be removed after observing the due process of law. After observing the due process of law.
Your lordship has granted liberty to the petitioner, any other aggrieved person, your lordship, that may be there.
So they will
2
come
pages
individually,
affidavit,
Lordship.
by any interested person
Lordship.
or any interested / public respected person,
Lord.
including the petitioner.
Lord.
My lord, and in terms of the Supreme Court order, my lord.
We have said, in terms of the Supreme Court,
That is.
Deeply obliged.
Pleasure.
the petition stands closed.
In some cases, my lord, they have violated today some contempt petition filed before the Supreme Court, in which, my lord, again they state.
Pleasure, Lordship.
Item 29 for hearing.
Yes, Mr.
May it
Chair.
please your lordship. My lord, the matter relates to settlement of a mining area, my lord. Now,
Was this the same thing which was argued on the last occasion by council, by outside council? No.
no,
Not what Mr. Krishnan had argued. No.
no, that's not the one.
So you were there in that matter.
That is another, I'm there. So Venugopal's son is there, yes.
And I remember the name. Mr. Krishnan.
Krishnan. My lord, what had happened in this case, the writ petitioner, that is respondent number 7, his bid was, technical bid was rejected on 2 grounds, basically. One ground was, my lord, that he did not upload a digitally signed and cross stamp papers. And secondly, my lord, he mentioned the name of the mining area incorrectly. Basically, these are the 2 grounds on which, my lord, the technical bid of the writ petitioner respondent was cancelled. Thereafter, my lord, this particular mining area was given to the respondent number 7, whom we represent. Appellant, respondent number 7 before the writ petition. Now, my lord, if your lordship would kindly come to page 259, that reveals why, my lord, the technical bid of the writ petitioner was rejected.
Page 259, Mr. Chair.
Yes, my lord. On 3/9/2021. Whereas as per clause 5 of the eligibility, general eligibility criteria, court fee stamp of ₹100 shall be pasted and cancelled on the format available on website in and then be crossed, scanned, digitally signed and uploaded in the website. However, on scrutiny of the document, it is found that bidder Messrs. Anjala Bosumati, resident of so-and-so, has not digitally signed the document as required under this clause. Whereas as per clause B1 D6 of schedule 1, format for technical bid, the bidder is required to submit court fee stamp of ₹100 shall be pasted and cancelled on the format available on the website in and then be cross scanned, digitally signed, uploaded on the website. However, bidder Anjala was resident of so-and-so, in contravention of the above clause of the bid document, has failed to comply with the clause and instead has submitted a document which is not legally signed as per the requirement of the above clause. Whereas as per clause D2 of the schedule 1 format of the technical bid, the bidder is required to submit an affidavit with the name of the mineral block for which the bid has been submitted. As there are many mineral block owned by the department, the correct name of the mineral block is provided.
Mr. Chaudhary, before that,
Yes,
the single judge passed an order on December 1, 2021,
yes,
setting aside the speaking order whereby the writ petitioner's claim
Correct.
was
correct,
rejected,
correct.
was rejected.
Yes,
Now, the writ petition was allowed
yes.
with direction to hold a fresh auction with the.
Not fresh auction, my lord, to reassess his technical bid, then to go ahead.
Where is that order?
Yes, my lord. That impugned judgment, please come to page 475, my lord. Please come to my lord, page 478. Internal page would be 13, my lord. Internal page 13. There is one aspect, my lord, the otherwise the period is also coming to an end in November.
That is why I've asked this question.
My lord, without recording my concession, my lord,
No, we will not.
what can be done is, my lord, let them go ahead with the fresh tender. Everything new.
Just a minute.
Yes.
Let us see what the
Yes,
judge
yes,
has said.
para 28. Before examining the validity of the aforesaid reason, the basis of such a course adopted for evaluation of bid of the petitioner is to be examined. In additional affidavit filed by the respondent number 6 on 9/5/22 in WPC so and so, reference has been made to a communication dated 7/8/21 by Conservator of Forest North Assam Circle to DFO Demaji regarding complaints received against some of the bidders, including the that of the petitioner. By said communication, DFO has been asked to revisit the technical bid. Pursuant thereto, it appears from the communication dated 26/8/21 that DFO Demaji has examined the matter. It appears that complaint against petitioner was by so and so. But kindly skip this portion. Kindly come to me, Lord. Para 31. In any event, the first reason cited is that court fee stamp was not digitally signed by the petitioner.
No, that's that apart. We'll see
Yes.
the directions issued by him.
Direction is at, my lord, page para 35.
Please read that.
In view of the above, both the writ petition stands allowed and the impugned speaking order passed by DFO Demaji always work order in favor of respondent number 5 for Mohol in question as set aside. Accordingly, e-action for adjudging highest financiability is to be redone.
No, therefore it is not re-evaluation.
By allowing petitioner to participate and consider her bid in accord thereafter settle the Mohol in question with the highest price that may be faced.
So therefore,
May be undertaken and complete experience of public interest.
no, therefore it is totally e-auction, not re-evaluation. It's e-auction. It's re-auction. They can.
No, if it is re-auction, we have no objection.
But it says so. The e-auction of judging the highest is to be redone.
No, my lord, redone.
Redone is what? E-auction. They don't say evaluation.
Yeah, the court stepped in the stage of technical evaluation. So the financial bid was left there. The court said you go for you are allowing.
What is the meaning of the word e-auction?
Yes, my lord. It's fresh basically.
Lordship will clarify that position, my lord.
We are also, my lord.
What are you interested in, state?
My lord,
What do you say, Forest Department?
well, we had already filed an affidavit.
Forget about affidavit you have filed. How do you wish it to be concluded?
My lord, we want is this to be go for a fresh tender, my lord.
Yeah.
What have you done after this?
They had filed appeal, my lord. Status quo was directed, my lord. Status quo.
Interim order.
Interim order is there, my lord.
What is
And-
the status?
Status quo as the parties, my lord. Nobody has done anything.
And the work has not been, work is as it is.
No, my lord, that area, we had carved out a separate area, given it, we are continuing the government permit, government permit.
So nobody is operating.
Effectively, nobody is operating.
Nobody's operating. And we shunted out this.
When was the order of stay passed?
While moving the petition order to Kimantari. 1 second, my lord.
Stay means Mr. Chaudhary's clients were, then the LOI was already issued for you. But you did.
December 23, my lord.
But you did not pass, you did not do any work.
Yes. No, because my lord, that financial bill.
Just a minute. Mr. Chaudhary, I'll contact your client, Mr. Gogoi. You take instructions of the forest department, return their EMIs. No, what is that called? Security deposits. Go for fresh auction for the leftover work. We'll clarify, because you have not proceeded with the work since 2021.
Yes.
Yes, ma'am.
So take instructions, come back to us tomorrow, day after tomorrow. We conclude.
No, well, I have already taken instruction.
What instructions have you taken?
My lord,
My lord,
I-
only
I
thing is
settled
status
them today.
quo means
Yesterday, I
you
was,
have to
I
permit
called
us
them
to
up
work.
that what is going on actually.
Hmm.
They said, I just advised them to that, are you ready for a fresh settlement? Because prices have increased now.
Yes.
So they are ready for a fresh settlement.
So we interpret the orders the same way.
My lord.
Yes.
And we clarify. Go for a fresh. Mr. Chaudhary,
The security part has to be refunded and let them go ahead.
we offered it from our side.
Yes.
We offered it from our side.
No. That will be subject to the some verification by the officers.
The only
because-
difficulty is that.
No, my lord, the part, there was some work on his part, some work, a portion of work. Some
How
work.
can there be work? There was a status quo order, meaning whatever is put.
Mr. Gogoi, you don't understand what you speak.
My lord, no, before the court interfered, my lords, see, there, some portion, some work was carried on.
I think you have, see, your argument should be purposive. Mr. Chaudhary is saying that he has no objection. You are talking about that he has work. What are you doing, Mr.?
My lords, I am saying before the learned single just interfered, my lords. Before that, some portion may
Is
be.
he making a hue and cry about that?
That is up to
When
him,
he
my
is
lords.
not making it, why do you have to create a ghost and then kill it?
No, my lords, if
He will
again-
then ask you for payment. Mr. Gogoi, if you
Only
don't
thing is,
understand, I
like,
can't
my
help you.
security deposit and performance
Exactly.
guarantee should be refunded.
That you must return. ऐसा थोड़ी है.
No, কাম কৰিছিল নে তুমি? অলপ উঠাইছিল নে?
Who appears for the writ petitioner? Yes, Mr. Mahant.
My lord,
We are concluding this.
my lord,
The reason is that so many years have passed.
my lord,
Now it is no great fun in deciding, evaluating and all that.
my lord,
They are also agreeable for fresh auction.
my lord.
In fact, the judge meant fresh auction. I don't know how it was interpreted like that.
Because 5 years, already 4 years were left, my lord. On
This November, if the time will come.
2026 will be a.
Also fresh auction.
My lord.
No party will be benefited otherwise.
My lord.
Now with the escalated cost, I think
Yes.
the government also would benefit. No,
Yes,
government would not benefit.
No, government will benefit because they will get higher revenue.
Because this time revenue will be higher, my lord.
We concluded.
My lord.
Take note. We have heard Shri Gen Chaudhary, learned senior advocate for the appellant, Mr. B. Gogoi for the forest department. You are Mr.
D Gogoi, my lords.
D for Delhi.
Yes, please.
Mr. D. Gogoi for the
Yes,
forest
Dixit, my
department. And Mr. T.J. Mahanta, learned senior advocate for respond number?
5.
Respond number 5/writ petitioner. The tender process for the mining rights began with the NIT, began with the issuance of NIT by the DFO Dhemaji on June 11, 2021, inviting bids for the Mahal. Bids were submitted online and technical evaluation was conducted. The bid of respond number 5/writ petitioner was initially cleared, but later rejected by a speaking order dated 3rd of September 2021 for the bid reflecting two defects. Semicolon. Roman 1. There was a failure to digitally sign a ₹100 court fee stamp. And Roman 2, incorrect naming of the Mahal in the affidavit of respond number 5. bracket, calling it Simon Quarry instead of Simon, Simon Sand and Gravel, mining concession area. This will be in bracket. The affidavit of respondent number 5 was also found to be erroneous for the reason of certain missing documents. In that event, the bid of the appellant was accepted and a letter of intent was issued on September 9, 2021. The security deposit was made 10 days later and the work order was issued. The writ petitioner challenged the decision to award the contract to the appellant by WPC number 1609 of 2022, alleging violation of principles of natural justice and that the defects pointed out in the bid of the writ petitioner being of a minor nature and easily curable. Easily curable. Before the writ court, the Forest Department defended the rejection of the bid of respondent number 5, explaining that the tender conditions were strict and sacrosanct and the defects justified disqualification. The appellant also naturally supported the stand of the Forest Department and explained that his bid was free of anomalies in comparison to the defects in the bid of respondent number 5, which were fundamental, rendering the bid of respondent number 5 invalid under clause 13 of the tender documents. It was also argued before the writ court that the third party right had accrued and therefore no interference was required to be made with the decision of the Forest Department. Okay, right? However, the writ petition was allowed. The speaking order dated 3rd of September 2021 referred to above and the consequent work order of December 1, 2021 were set aside. A fresh e-auction was directed to be made to determine the highest bid, allowing the parties bracket writ petitioner and the appellant to participate and have their bids evaluated appropriately, keeping in mind the public interest of maximization of revenue. However, it appears as on date that the direction of a fresh e-auction for judging the highest financial bid was misunderstood to mean that the financial evaluation only was required to be done upfront. The Forest Department proceeded in that direction, but the work was told for the reason of an interim order passed in this appeal. The filtrate of this, the filtrate situation of this was that the work could not be continued, and the auction which and the period of auction and the time period of the auction was substantially consumed, leaving only few months for the auction to remain valid. Under such circumstances, and with the consent of the parties, we clarify that the impugned judgment ought to have been understood as a direction for a fresh e-auction for the work, for the mining right. The appellant as well as the respondent, the appellant as well as the respondent number 5, as also the Forest Department. The appellant as well as the respondent number 5 are ready. Respondent number 5 are ready for a fresh e-auction of the mining right, in which both of them would be permitted to participate. The state in the Forest Department also is agreeable for the same, for the reason, primarily for the reason that without this endeavor, the period of the earlier auction would expire, leaving the work unfinished either way, in any way, leaving the work unfinished anyways. We therefore deem it appropriate, with the consent of the parties, to conclude that a fresh e-auction shall be made, allowing the appellant and respondent number 5, as also other participants, the occasion to get their respective bids evaluated. And a decision be taken on such evaluation for the work order. We also direct that in this event, the security deposit of the parties be also returned as expeditiously as possible, preferably before floating a new tender, floating a fresh tender. The appeal stands disposed of accordingly. Maximization of revenue, maximization of satisfaction. Security, you'll only get back your security.
Security.
No. It's over.